Hello friends, you are welcome again to this YouTube channel, Dr. G.K. Goswami IPS. I am sorry I was missing this opportunity to interact with you since last about a month because I was engaged in my academic activity, my official commitments in UPSIFS, Lucknow and other domains. Here today I was just reading some articles and other areas while interacting with the professionals of information technology, cyber forensics, cyber security. Then I stuck with one important topic, that information technology law and cyber law, are they same or there is any difference? So I thought appropriate to discuss the subtle difference between IT laws and cyber laws. So let us go friends and have a look. It will be a very succinct and crisp discussion for about 10 minutes, but I assure you that you will enjoy it thoroughly. So we are going to discuss briefly today information technology law and cyber laws and interplay. So as you know that most of the time I prefer to give you a sketch, a brief description, a comparative matrix. So here is the matrix, a comparative matrix for IT laws and cyber laws. So if we see the definition part, the IT laws in general, my dear friends, before entering into the definition business, let me clarify first that information technology is a very wide term, and if we see in the set theory, IT laws is a bigger set and cyber laws is the subset of IT law, meaning thereby that all cyber laws are the part and parcel of IT laws, but all IT laws are not cyber laws. I hope this makes you some sense and it is clear. So let us go for the definition. Basically IT laws, as I mentioned, they govern creation, dissemination, use and regulation of information technology in various fields, meaning thereby that whatever we talk about in cyberspace, right, those areas which are invisible, because you know that cyberspace is invisible, but cyberspace is an asset, it is a property, it has corporeal rights to the holder. Okay. So IT laws deals with how you create anything related to cyberspace. Okay. But cyber law, my dear friends, they confined only to cyber security, cyber crime and any digital network. So this definition will be more clear when we will move further. If we see the primary goal, I think the definition part will be more clear when we see the primary goal. As I mentioned already that IT laws are wider, they have wide perspective, they are dealing with technology for social, economic and governance part of the system. That means the entire gambit the IT laws are dealing with. That is why we have information technology law. You will surprise, we do not have cyber law act or anything of separate nature. Cyber laws are part and parcel of information technology only. If we see the primary goal of cyber laws, they basically deal to ensure safe and secure cyberspace by preventing and punishing legal violations. So if somebody actually violate any rules, norms which are operable in cyber matters, then it falls under the cyber law. Now the scope, as I mentioned, IT laws are wider because it encompasses everything related to IT sector. They deal with e-commerce, they deal with e-governance, they deal with data protection. So as I mentioned that IT is a bigger sector. So if you see that entire thing falls under IT laws, but if somebody violates or if you want to have a separate system of security, then it falls under cyber law. As far as scope of cyber laws is concerned, as I mentioned, it has narrow scope. It deals with cyber security, cyber crime and online interactions. Online interactions means that how you should behave on cyberspace when you are interacting people. Otherwise, in case you violate, then it amounts to cyber crime. The key focus area, if we see, then in IT law, we recognize electronic record under section 4 of IT Act. Likewise, there are so many regulations on e-commerce and particularly online contract. And online contract, how they have to be formulated, it is dealt under section 10A of the IT Act. However, in cyber laws, as I already mentioned, we deal with cyber crime such as hacking. You might be aware these days that a lot of people get victimized because of cyber arrest. So that is also part and parcel of cyber crime. Again I repeat, my dear friends, because these days by and large every day in many newspapers you might be noticing that even educated people, professors, doctors, they are victimized by one cyber crime named cyber arrest or digital arrest. It is a crime. There is no system to arrest anybody through digital arrest. So be careful, be aware and spread this awareness among others. So as I mentioned, the key focus area in cyber law is cyber crime, cyber security, online obscenity, child pornography, cyber crime online and so on and so forth. So that is the area. Now the legal instrument by which we deal. As I mentioned, whether it is IT laws or cyber laws, the same act deal with them in India, and that is IT Act 2000. Although there are so many amendments subsequent period in last 20, 24, 25 years. But the major section for the cyber law, or you can say cyber security, cyber crime and things like that, major section of IT Act are section 66. And if you remember this section 66, Shreya single case of 2012, by which in Maharashtra a case was slapped under section 66A of IT Act when two girls were talking about the bandh caused by the police for various other reasons, right? So there were some procession and that was the reason why this was abrogated by the Supreme Court. In Shreya single case, the section 66A was found null and void and that was abrogated from the IT Act. Another section, important section is section 67, likewise 69. If we see the international perspective, because our IT Act is also in consonance with international legal framework, we are the member of United Nations. So there is one important commission called UN Commission on International Trade Law, UNCITRAL, and there are so many other conventions and regulations and we follow, and our IT Act adopt most of the directives given in these conventions, protocols and all. However, the cyber laws, they are by and large covered through Budapest Convention, bilateral agreements and so on and so forth. Why these international conventions are important? Because these laws or these domains of cyber law, they do not have very clear-cut jurisdictions. You may be sitting in India, but the criminal or the partner to whom or with whom you want to have some commercial business or something, he may be sitting outside India, any part of the world. So now the physical boundaries, geographical boundaries are melting, and that is why the international framework in cyberspace becomes very, very important. So with this, I hope I could make it clear. Again, we will meet soon and will exchange ideas, exchange experience for the better society. Till then, thank you. Bye.